Hey guys, so in this video, I'll be discussing Title 3 or Crimes Against Public Order. So it's quite lengthy. It's articles 134 to 160. It's almost 30 articles. So in this video, unlike my other videos where I give examples, illustrations, I'll just be citing the elements of each article. So it's more like a video audio element type of CODAL. So I hope it still helps your review for criminal law too. So this is again Title 3 or Crimes Against Public Order. So let's begin. Chapter 1 is rebellion, coup d'etat, sedition, and disloyalty. And Section 1 is arbitrary detention and expulsion. So we go now to Article 134 or rebellion or insurrection. So how is this committed? So the definition of rebellion is a crime of masses, a vast movement of men and a complex net of intrigues and plots where the object of the movement is completely to overthrow and supersede the existing government, while insurrection is a movement which seeks merely to effect some change of minor importance or to prevent the exercise of government authority with respect to particular matters or subjects. And on the other hand, terrorism is when a person commits rebellion or insurrection, sowing and creating a condition of widespread and extraordinary fear and panic to coerce the government to give in to an unlawful demand. So we go now to the elements of Article 134. So there must be a public uprising and taking up arms against the government. Then the purpose of the uprising is political. It's either to remove from the allegiance to said government or its laws, territory of the Philippines or any part thereof, any body of land, naval, or other armed forces, to deprive the chief executive or the president, or Congress, wholly or partially, any of their powers or prerogatives. So, ano ba yung difference ng rebellion and treason? Treason was already discussed in another video. So, in rebellion, it is levying war during the time of peace. Diba, isa sa elements ng treason is it has to be in the time of war. So, in rebellion, it's levying war during the time of peace and always involves the taking up of arms. While in treason, it is levying war during the time of war. And when performed to aid and done by mere adherence to the enemy, giving them aid or comfort. So the person deemed leader of the rebellion in case he is unknown is any person who in fact directs the others, spoke for them, signed receipts and other documents issued in their name, performed similar acts on behalf of the rebels. Then the persons who are liable for rebellion includes any person who promotes, maintains, and heads a rebellion or insurrection, or any person who, while holding any public office or employment, takes part therein by engaging in war against the forces of the government, destroying property or committing serious violence, exacting contributions or diverting public funds for the lawful purpose for which they have been appropriated. So we go now to Article 134A, so coup d'etat. So what are the elements of coup d'etat? First is that the offender is a person or persons belonging to the military or police or holding any public office or employment. So remember, yung offender are persons na military sila, police sila, or government officials sila, public office or employment. So it is committed swift attack accompanied by violence, intimidation, threat, tragedy, or stealth. Then directed against duly constituted authorities, any military camp or installation, communication networks, or public utilities, other facilities needed for the exercise and continued possession of power. Then singly and simultaneously carried out anywhere in the Philippines for the purpose of seizing or diminishing state power with or without civilian support or participation. So now we move on to Article 135. So the penalty for rebellion, insurrection, or coup d'etat. So who are the persons liable for rebellion, insurrection, or coup d'etat? So the leaders here are any person who promotes, maintains, or heads a rebellion or insurrection, or any person who leads, directs, or commands others to undertake a coup d'etat. In the absence of known leaders, any person who, in fact, directed the others, spoke for them, signed receipts and documents issued in their name, as performed similar acts on behalf of the rebels and who are the participants therein in the said crimes. So any person who participates or executes the commands of others in rebellion, insurrection. So note that coup d'etat is any person not in the government service who participates, supports, finances, abets, or aids in undertaking a coup d'etat. So there are also private individuals who supports, finances, abets, or aids in the undertaking of a coup d'etat. So now we go to Article 136, or conspiracy and proposal to commit coup d'etat, rebellion, or insurrection. So first is conspiracy to commit rebellion. When two or more persons come to an agreement to rise publicly and take arms against the government for any of the purposes specified and decide to commit it. Then proposal to commit rebellion is when a person who has decided to rise publicly and take arms against the government for any of the purposes specified proposes its execution to some other person or persons. Bilis nung nung discussion because ang dami talaga ng articles. Anyway, so Article 137 is disloyalty of public officers or employees. So what are the elements of this crime? So there is an existence of rebellion. Then the offender must be a public officer or employee, and offender commits any of the following acts. First, fails to resist the rebellion by all means in their power. Second, continues to discharge the duties of their office under the control of the rebels. Or third, accepts an appointment to the office under the rebels. Note that the crime presupposes the existence of rebellion, then the offender must be a public officer or employee, and there must be a rebellion to be resisted. So the offender must not be in conspiracy with the rebels or coup plotters. If there are means to prevent the rebellion but the officer did not resist, he becomes criminally liable for disloyalty. However, if there are no means to resist, the officer is at no fault. So next is inciting a rebellion or insurrection. So what are the elements of this crime? So the offender does not take up arms or is not in open hostility against the government, but incites others to rise publicly and take arms against the government for any of the purposes of rebellion. And inciting is done by means of speeches, proclamations, writings, emblems, banners, or other representations tending to the same end. So, ano yung difference ng proposal to commit rebellion and inciting to rebellion? Parang they sound similar. So, sa proposal to commit rebellion, the person who proposes has decided to commit rebellion. While in inciting to rebellion, it's not a requirement that the person who induces another has decided to commit rebellion himself. So, a proposal is usually done, excuse me, privately, only between the one who proposes rebellion to another or via secret means. While the act of inciting is done publicly, kagaya nga ng sinabi, parang sa banners, may emblems, speeches, proclamations, writings. So next is sedition. Article 139 speaks of sedition. So what are the elements of sedition? First is the offenders rise publicly and tumultuously caused by more than 3 armed men or provided with the means of violence. So another is there is employment of force, intimidation, or other means outside of legal methods. So another is offenders employ to any of those means to attain any of the following objects. Go prevent the prosecution or execution of any law or the holding of any popular election, to prevent the national government or any provincial or municipal government or any public officer from exercising its or his function, or to prevent the execution of an administrative order, to commit for any political or social end any act or hate or revenge against private persons or any social classes, to commit for any political or social end any act of hate or revenge upon the person or property of any public officer or employee, or to despoil for any political or social end any person, municipality, or province, or the national government of all its property or any part thereof. So, what do we mean by tumultus? So, if caused by more than 3 persons who are armed or provided with the means of violence, we also define this. Remember, in another video, yung death caused in a tumultuous affray. They actually got the definition of tumultus from Article 153, which will be discussed later. So, yun na nga, yung tumultus daw is caused by 3 or more armed person. So, the purpose of this crime is not the overthrowing of the government, but the violation of public peace, public uprising, and an object of sedition must concur. So, under RA 8294, or the Act amending PD number 1866 of the Firearms Law, sedition absorbs the use of unlicensed firearm as an element. So hence, it is not an aggravating circumstance, and the offender can no longer be prosecuted for illegal possession of firearm. So we go now to Article 140, or the penalty for sedition. So the persons liable here are the leader of sedition and other person participating in the sedition. So the penalty here is under RA 10951. The leader of the sedition under Article 140 of the RPC shall suffer the penalty of prisión mayor in its minimum period and pay a fine not exceeding 2 million pesos. So other persons participating therein shall suffer the penalty of prisión correccional in its maximum period and a fine not exceeding 1 million pesos. O, di ba? Ang laki. Oh, it's okay. Anyway, we go now to Article 141, and it's conspiracy to commit sedition. So what are the elements of this crime? So first is an agreement and decision to rise publicly and for the purpose of attaining an object of sedition. So note that there is no crime of proposal to commit sedition. Then we go now to Article 142. So I'm quite fast. Hope you're keeping up. And the elements of this crime is that the offender does not take a direct part in the crime of sedition. He incites others to the accomplishment of any of the acts which constitutes sedition, and that the inciting is done by means of speeches, proclamations, writing, emblems, cartoons, banners, or other representations tending to the same end. So what's the purpose? It's to cause commotion and not exactly against the government. And its actual disturbance. Oh, sorry. Ayan. Saan na ba tayo? 142. Ayan. And its actual disturbance is it's not necessary. So there are different acts in inciting to sedition. Inciting others by means of speeches, proclamations, writings, emblems, cartoons, banners, and other representations, while the others uttering seditious words or speeches which tend to disturb or obstruct any lawful officer in executing the functions of his office. It's to instigate others to cabal and meet to get together for unlawful purposes, suggest or incite rebellious conspiracies or riots, or lead to tend to stir up the people against lawful authorities. So it's also writing, publishing, or circulating scurrilous, low, vulgar, mean, or foul libels against the government or any of the duly constituted authorities thereof, which tend to disturb the public peace, or knowingly concealing such evil practices. And considering that the objective of sedition is to express protest against the government and in the process creating hate against public officers, any act that will generate hate against the government or a public officer concerned or social class may amount to inciting to sedition. So we also have the anti-terror law now. Kung hindi ka na lang din pwedeng sabihin na inciting to sedition, pwede ka pang sabihin na terrorist. So the essence of seditious libel is its immediate tendency to stir up general discontent to the pitch of illegal courses or to induce people to resort to illegal methods in order to redress the evils which press upon their minds. So we move on now to Chapter 2. So Chapter 2 is crimes against popular representation, and Section 1 is crimes against legislative bodies and similar bodies. Sorry for bodies, sand, and it's and. Anyway, so Article 143 is acts tending to prevent the meeting of the assembly and similar bodies. So the elements of this crime is there must be a projected or actual meeting of the National Assembly or any of its committees or subcommittees, constitutional committees or division thereof, or any provincial board or city or municipal council or board. So the offender who may be any person prevents such meeting by force or fraud. Note that any stranger, even if he be the municipal president himself or the chief of the municipal office, must respect the meeting of the municipal council presided over by the vice president, and he has no right to dissolve it through violence and under the pretext of lack of notice to some members of the council, which has not apparent but required an investigation before it could be determined. Then we go now to disturbance of proceedings in Article 144. So the elements of this crime is that there must be a meeting of the National Assembly or Congress in its committees or subcommittees, committees, constitutional commissions or committees, or divisions thereof, or of any provincial board or city or municipal council or board. And the offender does any of the following acts. So first, he disturbs any of such meetings. Second, he behaves so as to interrupt its proceedings or to impair the respect due while in the presence of such bodies. So note that one who disturbs the proceedings of the National Assembly may also be punished for contempt by the Assembly, and the complaint for disturbance of proceedings may be filed by a member of the legislative body. Is violation of parliamentary immunity. And what Article 145 is violation of parliamentary immunity. And the acts punishable here is by using force, threat, intimidation, or frauds to prevent any members of the Congress from attending the meeting of the Assembly or any of its committees, constitutional commissions, or committees or divisions thereof, or from expressing his opinions or casting his vote. So the elements of this crime is that the offender uses force, threat, or intimidation, and that the purpose of the offender is to prevent any member of the National Assembly from attending the meetings of the Assembly or any of its subcommittees or committees, expressing his opinion or casting his vote. So by arresting or searching any member thereof while Congress is in a regular or special session, except in case such member has committed a crime punishable under the code by a penalty higher than prison mayor. So that the offender is a public officer or employee, that he arrests or searches any member of Congress, and that the Congress at the time of the arrest or search is in a regular or special session, and that the member searched has not committed the crime punishable under the code by a penalty higher than prison mayor. One. Immunity under Section 11, Article 6 of the 1987 Constitution, it does not protect the members from responsibility before the legislative body itself. So, offense punishable by penalty of prison correctional, 6 months and 1 day to 6 years or lower. So, the members of the Congress are immune pag ganito.
Alam mo ba, na nahuli kami, walang lisensya,
Anyway, so yung members of Congress immune nga pag yung penalty is 6 months and 1 day to 6 years lang. So yung offense is punishable by penalty of prison mayor or 6 years and 1 day to 12 years, yung mas mataas na. So yung congressman or yung legislator may be arrested even while Congress is in session. So to be consistent with the 1987 Constitution, the phrase by a penalty higher than prison mayor in Article 145 should be amended to be read by the penalty of prison mayor or higher. Excuse me. So Chapter 3 is illegal assemblies and associations. Now, Article 146 is illegal assemblies. So what is a meeting? So it's a gathering of a group, whether in a fixed place or moving. And illegal assemblies, the acts punishable under this article is that a meeting attended by armed persons for the purpose of committing any of the crimes punishable under this code. So the elements of the first act is the following. So yung meeting, gathering of group of persons, whether in a fixed place or moving. So the purpose is to commit any of the crimes punishable under the code, and it's attended by at least 4 armed persons. So the second act punishable is a meeting in which the audience, whether armed or not, is incited to the commission of the crimes of treason, sedition, or assault upon a person in authority or his agent. So the elements of the second act is meeting, gathering, or group of persons, whether in a fixed place or moving, and the audience, whether armed or not, is incited to the commission of the crime of treason, rebellion, or insurrection, sedition, or direct assaults. And the persons liable for this crime is the organizers or leaders thereof, and the law imposes a heavier penalty upon the organizers or leader. And those merely attending are also punished. So the presumption is where a person carries an unlicensed firearm in the said meeting is that the purpose of the meeting, as so far as he is concerned, is to commit acts punishable under this code, and he shall be considered as the leader or the organizer of the meeting. Note, however, that not all present at the meeting of the first form of illegal assembly or the first act must be armed. So those who, by means of speeches, printed matter, or other means of representation, appear to have instigated the proceeding are the leaders or organizers of the meeting. So the responsibility of persons merely present at the meeting, if they are not armed, arresto mayor. If they carry arms like bolos or knives or licensed firearms, prison correctional. if any person carries unlicensed firearm in this crime, it is presumed that the purpose for the meeting, insofar as it is concerned, is to commit acts punishable under the code, and he is considered the leader of the organ or the organizer of the meeting. So next is Article 147, or illegal associations. And in this article, those totally or partially organized for the purpose of committing any of the crimes punishable under this code, and those totally or partially organized for some purpose contrary to public morals. So public morals are acts that affect the interests of society and public convenience. It is not confined to the limited concept of good customs, and covers a system of judicial precepts founded on human nature that regulate public convenience. So it refers to acts that are in accordance with natural and positive laws. So the persons liable here are the founders, directors, and presidents, and the members. So we go now to chapter 4, or assault upon and resistance and disobedience to persons in authority and their agents. Article 148 is direct assault. So there are forms of direct assault. The first form is without public uprising, by employing force or intimidation for attaining rebellion or sedition. So we go first to the elements of the first form. So the elements of the first form is that the offender employs force or intimidation, that the aim of the offender is to attain any of the purposes of crime of rebellion or any of of the objects of the crimes of sedition, and third is that there is no public uprising. So it is not necessary that the offended party in the first form be a person in authority or his agent. The stature of the offended person is immaterial. The crime is manifested by the spirit of lawlessness. So the accused prevents by force the holding of a popular election in certain precincts without public uprising. So the second form is without public uprising, that by attacking, by employing force, or by seriously intimidating or seriously resisting any person in authority or his agents while engaged in the performance of official duties. So the elements of the second form includes that there is no public uprising first. Pangalawa, the offender makes an attack, employs force, makes a serious intimidation, or makes a serious resistance. Then the third one is that the person assaulted is a person in authority or his agent. Then at the time of the assault, the person in authority or his agent is engaged in the actual performance of official duties. So the motive is not essential, or that he is assaulted by reason of the past performance of official duties, and here the motive is essential. So the offender knows that the one he is assaulting is a person in authority or his agent in the exercise of his duties. So what is qualified direct assault? So when the assault is committed with a weapon, when the offender is a public officer or employee, when the offender lays a hand upon a person in authority. So when the person in authority or the agent provoked or attacked first, the innocent party is entitled to defend himself and cannot be held liable for assault or resistance, neither for physical injuries, because he acts in legitimate self-defense. So we go now to direct assault. So direct assault intends to punish acts that are done in the spirit of lawlessness for the first form of direct assault, or contempt or hatred for the authority or the rule of law, in which the second form of direct assault. So the only time when it is not complexed with material consequence is a light felony, that is light physical injury. So direct assault absorbs the light felony. The crime of direct assault cannot be separated from the material result of the act. So during direct assault, it is enough that the offender knew that the person in authority was performing an official function, whether whatever may be the reason for the attack, although what may have happened was a purely private affair. So may simply be the material consequence of the unlawful act of murder or homicide. So further, the the crime to be to for the crime to be direct assault, the attack must be by reason of his official function in the past. So it is not necessary that the person in authority or his agent is in the actual performance of his official duty when attacked or seriously intimidated. So there can be no direct assault upon a disobedience to any authority by another when both contend in the exercise of their respective duties. So there are two kinds of assault in the second form. So first we have simple, and second is we have qualified. So in murder or homicide, a judge was killed while walking home because of an unpaid debt. In direct assault with murder or homicide, the offender killed the judge because the judge is so strict in the fulfillment of his duty. So that's the difference. So we go now to Article 149, or indirect assault. So the elements of this crime is that a person in authority or his agent is the victim of any of the forms of direct assault defined in Article 148. A person comes into aid of such authority or his agent, and the offender makes use of force or intimidation upon such person coming to the aid of the authority of his agent or his agent. So note that there is no direct assault when there is no indirect assault, rather, when there is no direct assault. So due to the amendment of Article 152 without the corresponding amendment in Article 150, the crime of indirect assault can only be committed when an assault is upon a civilian giving aid to an agent of the person in authority. He does not become another agent of the person in authority. So the private individual in such a case is not coming to an aid of a person in authority, the policeman being an agent of a person in authority. So we go now to Article 150, or disobedience to summons issued by the Congress, its committees, or subcommittees, by the constitutional commissions, its committees, subcommittees, or divisions. So the acts punished here is by refusing without legal excuse to obey summons of Congress, its special or standing committees and subcommittees, the constitutional subcommittees, committees, or divisions, or by any commission or committee chairman or member authorized to summon witnesses. So second is by refusing to be sworn or placed under affirmation while being before such legislative or constitutional body or official. Third is by refusing to answer any legal inquiry or to produce any books, papers, documents, or records in his possession when required by them to do so in the exercise of their functions. Fourth is by restraining another from attending as a witness in such legislative or constitutional body, or by inducing disobedience to a summons or refusal to be sworn by any such body or official. So note that the National Assembly is now the Congress in the Philippines, consisting of the Senate and the House of Representatives. So the power of inquiry with process to enforce it is an essential and appropriate auxiliary to the legislative functions. But when the investigation is for the purpose of passing a legislative measure, such investigation comes under the province of the committee of the House of Senate. So any of the acts punished under Article 150 may also constitute contempt of the National Assembly. So only disobedience without legal excuse is punishable. Article 150 may not apply when the papers or documents may be used in evidence against the owner thereof, because it would be equivalent to compelling him to be a witness against himself. And Article 151 is resistance and disobedience to a person in authority or such agents of such person. So the elements of resistance and serious disobedience. For the first paragraph, a person in authority or his agent is engaged in the performance of official duty or gives a lawful order to the offender. The offender resists or seriously disobeys such person in authority or his agent. The act of the offender is not included in the provision of Articles 148, 149, and 150. So the second is the elements of simple disobedience, or the second paragraph. So an agent of a person in authority is engaged in the performance of an official duty or gives a lawful order to the offender. The offender disobeys such agent of a person in authority, and such disobedience is not of a serious nature. So the order given must be lawful. Otherwise, the resistance is justified. When the attack or employment or of force is not deliberate, the crime is only resistance or disobedience. So note that the act of lying on the road and refusing despite the order of the for example, police major to get out there from constitutes the crime of simple disobedience. Picketing may be done and considered as a nuisance if it constitutes an obstruction to the free use of property so as to substantially to interfere with the comfortable enjoyment of life or property, or if it constitutes an unlawful obstruction to the free passage or use in the customary manner of a street. So there's no kind of peaceful picketing. So any attack or employment of force considered only as a resistance or serious disobedience when the attack or employment of force was not serious and deliberate and was only done to resist and not to purposely injure the person in authority or his agent. We go now to Article 152. So the persons in authority and agents of persons in authority who shall be deemed as such. So who are the persons in authority? So it's any person who shall directly vested with jurisdiction, whether as an individual or as a member of some court or governmental corporation, board, or commission. So these are the barangay captain, barangay chairman, teachers, professors, persons charged with the supervision of public or duly recognized private schools, colleges, and universities, and also lawyers in the actual performance of their professional duties or on the occasion of such performance, while the agent of person in authority or any person who, by direct provision of law or by election or appointment by competent authority, is charged with the maintenance of public order and protection and security of life and property. So it includes the barangay councilman, the barrio policeman, the barangay leader, any person who comes to the aid of persons in authority. Section 388 of the Local Government Code says that for purposes of the revised penal code, the punong barangay, sangguniang barangay members, and members of the lupong tagapamayapa in each barangay shall be deemed as persons in authority in their jurisdictions, while other barangay officials and members who may be designated by law or ordinance and charged with the maintenance of public order, protection and security of life, property, or the maintenance of a desirable and balanced environment, and any barangay member who comes to the aid of persons in authority shall be deemed as agent of persons in authority. So we go now to chapter 5, or public disorders. This is what I said a while ago. So Article 153 is tumultuous and other disturbances of public orders. Tumultuous disturbance or interruption liable to cause disturbance. So what are the acts punished here? So one is causing any serious disturbance in a public place, office, or establishment, interrupting or disturbing performances, functions, or gatherings, or peaceful meetings if the act is not included in Articles 131 and 132, making any outcry tending to incite rebellion or sedition in any meeting, association, or public place, displaying placards or emblems which provoke a disturbance of public order in such place, and burying the of a pump the body of a person who has been legally executed. So the essence is creating public disorder. The crime is brought about by creating serious disturbances in public places, public buildings, and even in private places where public functions or performances are being held. So if the act of disturbing or interrupting a meeting or religious worship is committed by a private individual or even by a public officer, but he is a participant in the meeting or religious worship which he disturbs or interrupts, Article 153, not 131 or 132, which punish the same acts if committed by public officers who are not participants in the meetings or religious worship, is gonna be applicable. So if done unconsciously or without intent to incite the listeners to rise to sedition or rebellion, this article applies. So the serious disturbance in the first act punished must be planned or intended. The penalty next higher in degree shall be imposed upon persons causing any disturbance of a tumultuous character. So it is tumultuous if it is caused by more than 3 persons who are armed and or provided with means of violence. Armed does not refer to bearing firearms but includes even big stones, anything that is capable of causing grave injury. And outcry means that shouting provocative or subversive words tending to stir up the people to obtain by means of force or violence any of the objects of the rebellion or sedition. So if a convict legally put to death is buried with a pump, it is also disturbance of public order. He should not be made out as a martyr, as it might incite others to hatred. So the one who fired the submachine gun committed 2 offenses, causing serious disturbance in a public place, the people present becoming panicky and terrified, and serious physical injuries through reckless imprudence, although they arose from the same act of the offender. So this is People versus Bacolod. So we go now to Article 154, or unlawful use of means of publication and unlawful utterances. So the acts punished here is that one, any person who, by means of printing, lithography, or any other means of publication, shall publish or cause to be published as news any false news which may endanger the public order or cause damage to the interest or credit of the state. So it's also any person who, by the same means or by words, utterances, or speeches, shall encourage disobedience to the law or to the constituted authorities, or praise, justify, or extol any act punished by law. Then any person who shall maliciously publish or cause to be published any official resolution or document without proper authority or before they have been published officially, or any person who shall print, publish, or distribute or cause to be printed, published, or distributed books, pamphlets, periodicals, or leaflets which do not bear the real printer's name or which are classified as anonymous. Actual public disorder or actual damage to the credit of the state is not necessary. So the mere possibility of causing such danger or damage is sufficient. The offender must know that the news is false. If the offender does not know that the news is false, he is not liable under this article, there being no criminal intent on his part. So if there is no possibility of danger to the public order or of causing damage to the interest of or of, or credit of the state, then Article 154 is not applicable. So the crime here is what I just stated. There is also means to disturb the public order. So we go now to Article 155 or alarms and scandals. So the acts punished here is 1. Discharging any firearm, rocket, firecracker, or other explosives within any town or public place calculated to cause alarm or danger. 2. Instigating or taking active part in any charivari or other disorderly meeting offensive to another or prejudicial to public tranquility. Third is disturbing the public peace while wandering about at night or while engaged in any nocturnal amusement. Fourth is causing any disturbance or scandal in public places while intoxicated or otherwise, provided the act is not covered by Article 153. In the first act punished, the discharge of the firearm should not be aimed at a person. I think I gave an example in another video about this, yung sa Article 254, which is illegal discharge of firearms. But my example there was the firearm was discharged in a public place, and I think there what was said to be committed is under this article, alarms and scandals, kasi parang nanggugulo lang siya. So mere discharge of firearm towards another with intent to kill already amounts to attempted homicide or attempted murder or attempted parricide. It cannot be frustrated because the offended party is not mortally wounded. It is the result, not the intent, that counts. The act must produce harm or danger as consequence. So even if the persons involved are engaged in nocturnal activity like playing patintero at night or selling balot, if they conduct their activity in such a way that disturbs the public peace, they may commit the crime of alarms and scandal. So kita naman natin yan, but they can't really do it now because may curfew. Anyway, so scandal here does not refer to moral scandal as that one grave scandal in Article 200. The essence of the crime is disturbance of public tranquility. So charivari is a mock serenade wherein the supposed serenaders use broken cans, broken pots, bottles, or other utensils, creating discordant notes. It is actually producing a noise, not music. If the annoyance is intended for a particular person, the crime is unjust vexation. So the act of a person who hurled a general insult at everybody, there being 30 persons in the hall, and challenged the owner of the billboard hall to a fight, causing commotion and disorder so that the billiard game rather, had to be stopped momentarily. It constitutes mere violation of Article 155, paragraph 4, not Article 153. While the billiard hall is a public place, there was no serious public disorder. So we go now to Article 156, or the delivery of prisoner from jail. So the elements of this crime is that there is a person confined in jail or penal establishment, and the offender removes therefrom such person or helps the escape of such person, and that the person confined may be a mere detention prisoner. Of course, the prisoner may also be by final judgment. A hospital or asylum is considered an extension of the penal institution. The offender is usually an outsider, but the provision does not exclude public officers. Therefore, offenders may be private or public persons. So, violence, intimidation, or bribery is not necessary, but if such was employed, the penalty is higher. And to correlate the crime of delivering persons from jail with infidelity in the custody of prisoners punished under Article 223, 224, and 225. The crime under Article 156 is committed by a public officer when he is not in the custodian of the prisoner at the time the prisoner was made to escape. So if the public officer has the custody of the prisoner when such prisoner escaped, he is liable under Article 223 for infidelity in the custody of the prisoner. So the liability of the prisoner or detainee who escaped is a convict serving sentence by final judgment. The crime of evasion of service of sentence is committed by the prisoner who escapes if such prisoner is a convict serving sentence by final judgment. If it's only a detention prisoner, the prisoner who escapes does not incur liability from escaping if he does not know of the plan to remove him from jail. But if he knows and cooperates therein by escaping, he himself becomes liable for delivering persons from jail as a principal by indispensable cooperation. If three persons are involved, a stranger, the custodian, and the prisoner, three crimes are committed. First is infidelity in the custody of the prisoners. Second is delivery of prisoners from jail. And third is evasion of service of sentence. So the person who substituted for a prisoner by taking his place in jail is liable under this article because the removal of the prisoner from jail is by other means, that is, by deceit. So we go now to chapter 6, or evasion of service of sentence. So article 157 is evasion of service of sentence. The elements are the following. So the offender is a convict by final judgment. He is serving sentence which consists in the deprivation of liberty. And third, he evades service of his sentence by escaping during the term of his imprisonment. So the qualifying circumstances as to the penalty imposed is that if such evasion or escape takes place by means of unlawful entry, by breaking doors, windows, gates, walls, roofs, or floors, by using picklock, false keys, disguise, deceit, violence, or intimidation, through connivance with other convicts or employees of the penal institution, and the crime of evasion of service of sentence can be committed only by a convict of final judgment. If the accused escaped while the sentence of conviction was under appeal, he is not liable under Article 157. The judgment not having been final. So, and this is true if his appeal was later dismissed because he had escaped. So Article 157 is not applicable in sentence executed by deportation because the convict was not sentenced to imprisonment. Article 157 is applicable in destierro because destierro is a deprivation of liberty, though partial. So in leaving or escaping from jail or prison, that the prisoner immediately returned is immaterial. His voluntary return may only be a mitigating circumstance, being analogous to voluntary surrender, but the same will not absolve his criminal liability. So detention prisoners are not convicts by final judgment since they are only detained pending the investigation or the trial of the case against them. So we go now to Article 158, or evasion of service of sentence on the occasion of disorder, conflagrations, earthquakes, or other calamities. So the elements of this crime is that the offender is a convict by final judgment who is confined in a penal institution. There is disorder resulting from conflagration, earthquake, explosion, or similar catastrophe or mutiny in which he has not participated. He evades the service of his sentence by leaving the penal institution where he is confined on the occasion of such disorder or during mutiny, and he fails to give himself up to the authorities within 48 hours following the issuance of proclamation by the chief executive announcing the passing away of such calamity. Although Article 158 is silent, it is required that the convict must be won by final judgment because only a convict by final judgment can evade the service of his sentence. The leaving from the penal establishment is not the basis of criminal liability, but the failure to return within 48 hours after the passing of the calamity, conflagration, or mutiny had been announced. So those who return within 48 hours are given credit or deduction from the remaining period of their sentence equivalent to one-fifth of the original term of the sentence, not to exceed 6 months. But if the prisoner fails to return within the said 48 hours, an added penalty, also one-fifth, shall be imposed. But the one-fifth penalty shall be based on the remaining period of the sentence, not on the original sentence. But if the prisoner decided to stay despite the chance to evade, he will not be entitled for the one-fifth deduction. So Article 159 is other cases of evasion of service of sentence. So the elements is that an offender is a convict. He was granted pardon by the chief executive and he violated any of the conditions of such pardon. So conditional pardon is a contract. It's a contract between the chief executive who grants the pardon and the convict who accepts it. Since it is a contract, the pardoned convict is bound to fulfill its conditions and accept its consequences not as he chooses, but according to its strict terms. So the two penalties are provided for in this article. The first is prisión correccional and its minimum period if the penalty remitted does not exceed 6 years. And the second penalty is the unexpired portion of his original sentence if the penalty is higher than 6 years. The violation of a conditional pardon is a distinct crime. The violation of a conditional pardon is committed in the place where the subsequent offense is perpetuated. So the court cannot require a convict to serve the expired portion of his original sentence if it does not exceed 6 years. Article 159 does not provide that the accused shall serve such. The remedy is left to the president, who has the authority to recommit him to serve the unexpired portion of his original sentence. In violation of a conditional pardon, as a rule, the violation will amount to this crime only if the condition is violated during the remaining period of the sentence. Article 159, when the sentence remitted by the conditional pardon does not exceed 6 years, the penalty of the grantee who violates any of the conditions of such pardon is prison correctional and its minimum period. It is only when the penalty remitted by the pardon is higher than 6 years that the convict shall then suffer the unexpired portion of his original sentence. Since this chero has a duration of 6 months and 1 day to 6 years, under no circumstance may the penalty for violation of the conditional pardon be this chero. So we go now to the last chapter. Chapter 7 is the commission of another crime during service of penalty imposed for another offense. Article 160 is the commission of another crime during service of penalty imposed for another offense, and the elements are the following. So, the offender was already convicted by final judgment of one offense. He committed a new felony before beginning to serve such sentence or while serving the same. The second crime must be a felony, but the first crime for which the offender is serving sentence need not be a felony. Thus, if a prisoner serving sentence for one crime is found to be in possession of a firearm without a license, this article does not seem to apply because the law punishing illegal possession of firearms is a special law. So the new offense need not to be of different character from that of the former offense. So quasi-recidivism is a special aggravating circumstance where a person, after having been convicted by final judgment, shall commit a new felony before beginning to serve such sentence or while serving the same. He shall be punished by the maximum period of the penalty prescribed by law for the new felony. The special aggravating circumstance of quasi-recidivism cannot be offset by any ordinary mitigating circumstance because Article 160 specifically provides that the offender shall be punished by the maximum period of the penalty prescribed by law for the new felony. But if he is a minor under 16 years of age, the penalty can be lowered by at least 1 degree. Minority is a privileged mitigating circumstance, as we learned in our criminal law 1. So, when he is a habitual criminal, a quasi-recidivist may not be pardoned even if he has reached the age of 70 and already served out his original sentence. So that's it for Title 3. Thank you for listening. And I hope, even though there are a lot of background noises, you were able to fully comprehend the elements included in this title, which was quite lengthy. And good luck in your study for criminal law too, and good luck to me. Thank you for listening.